Good afternoon, everyone. Today we're going to talk about advance directives and guardianships. As you all know, Tools and Advice for Working Caregivers is an employee benefit program that helps to educate your working caregivers so they can remain present and productive at work and make sure that their aging loved one is taken care of. Advance directives are a huge part of making sure that an individual is able to care for and handle the day-to-day living of another person. So it's extremely important if you have employees who are caring for an aging parent or perhaps soon to be caring for an aging parent or loved one, that they make sure that their loved one has a power of attorney, healthcare proxy, a living will, and even a last will and testament. So what are these documents? We refer to them as advance directives. Basically, they're documents that a person signs while they have capacity to give instruction as to whom can take care of their affairs if they lose capacity. So a power of attorney, that's a legal document where a trusted family member or friend is appointed to act on your behalf regarding your financial affairs, including banking matters, real estate transactions, estate planning, and Medicaid planning. So this is naming someone to basically do anything and everything financial, not just seeing bank account statements, not just signing checks, but also perhaps helping you file a tax return, even signing your tax return as your power of attorney, selling real property, moving monies around from account to account, handling investments. So when you sign a power of attorney, you're giving the individual or your agent, as we call them, the ability to handle all of these things on your behalf. So if you were caring for somebody, wouldn't you think that it would make sense to have this document in place so that if you did need to act, you could do it very easily? Without the power of attorney, the banks won't talk to you, Social Security won't talk to you, the IRS will not talk to you. Nobody will have the authority to speak with you unless you are named as the agent under a power of attorney. An important thing to note is that the power of attorney does not take away any of your power to act on your own behalf. So if you're signing a power of attorney, or if your parent or loved one is signing a power of attorney, of course, if they're signing it, they have mental capacity or else they wouldn't be able to. So a lot of times the concern is, if I sign this and I name you as my agent, as my power of attorney, does that mean I can't sign my own checks anymore? Does that mean I can't pay my bills? Does that mean that I can't call the credit card company myself if I have a question? And the answer to that is no. The power of attorney doesn't take away the individual's ability to act on their own behalf. It simply gives another person the ability to also act. Okay, you're giving the agent the authority to make and implement management and financial decisions on your behalf. And unless it's revoked, the power of attorney will remain in effect until death. So how do you revoke a power of attorney? It must be revoked in writing, and it must be given, the revocation must be given to everybody who received a copy of the power of attorney. So if you sign a power of attorney and you decide you're going to give it to your financial advisor, you're going to give it to the 3 banks where you have accounts, you're going to give it to your CPA, you need to make sure that if at any time you ever revoke the power of attorney, that revocation goes to those same people. They need to know that that power of attorney, that agent that you named, is no longer your agent. Another thing to keep in mind with powers of attorney is that you can have more than one. So many times a married couple signing powers of attorney will name each other as their agent, but then they can also name a backup. So your backup can be a child, it can be 2 children, it can be a brother or sister, it can be more than one. You can also have more than one initially. If you don't have a spouse perhaps and you have adult children, you can name 2 children, 3 children, and you can specify whether you want them acting together or separately. most people right away, their initial thought is, I want them acting together. But together actually really means together. So if one of them is paying your bills and signing checks, all of them need to sign the check. So that can become extremely difficult, especially with families scattered all over the country these days. So we typically will recommend acting separately. That way, if you're naming more than one person, they can sort of divide and conquer the work. You know, this one can do this and that one can do that, and it makes it a little bit easier. But from the perspective of the TALK program, Tools and Advice for Working Caregivers, you can imagine how difficult the job of, say, an adult child could be if they're trying to perhaps do Medicaid planning or a Medicaid application or just handle mom's bill paying and finances. How difficult it would be without a power of attorney, how much more time it would take for them to do the smallest things, how much more stressful it would be for them to do, you know, very, very simple everyday things that we all do. And all of that is going to affect how they present at work. Whereas if they have a power of attorney and it's a proper form and it's properly executed, even if they still have things that they need to do for mom or dad, they have the document in place to allow them to do it with ease and without stress, which will certainly make for an easier work day for them. The next document is the healthcare proxy. Now, this is a document where you appoint someone to be your agent and make any and all healthcare decisions for you. Now, this is a little different from the power of attorney because this document takes effect only if and when you become unable to make your own healthcare decisions or communicate your wishes. So remember I said with the power of attorney, with the financial document, you're the agent and your parent still has the power to do their own thing, whatever they want to do. They're not losing any power. With the healthcare proxy, as long as mom or dad, they're able to communicate their wishes, even if they're terminally ill, as long as they can communicate what their wishes are, the doctors are going to listen to them. So if you're named as the agent on a healthcare proxy, you're only coming into play if there comes a time where the person can no longer communicate. Very important that a healthcare proxy contain a HIPAA release for disclosure of medical records. HIPAA is the Privacy Act. When you go to the doctor, they make you sign 1 million forms about who they can talk to and where they can leave a message, and that's for privacy purposes. If that language is not in your healthcare proxy, you run the risk that your agent will not be able to receive any medical records on your behalf, which can become quite difficult. If you're naming somebody to make healthcare decisions for you, you certainly want them to have access to any and all medical records so they can make the most appropriate decision. So I urge people who already have a healthcare proxy to go back and take a look at it and make sure that the HIPAA language is in there. Also different from the power of attorney, a healthcare proxy in New York State can name only one person at a time. So you can have an agent named and you can have a successor agent, a backup or 2 backups, but only one at a time. And that's because physicians, doctors don't want to be listening to 10 different people with 10 different ideas. They want one voice, one person who's going to communicate with them. It does not mean that families can't make decisions together. It simply means that there's one person who's going to communicate with the healthcare facility or with the doctor, whoever it might be. So in New York State, it's very important to have a healthcare proxy because New York State is a healthcare proxy state, which means that unless, again, you can still communicate your wishes, your healthcare agent is a person who could be making life or death decisions for you. So even though you're able to state your wishes, your healthcare proxy is, sorry about that, your healthcare proxy, your agent under your healthcare proxy is going to be making decisions about artificial nutrition, hydration, life support, and things like that, unless you're able to do it yourself. Now, in New York State, we also recommend something called a living will. The living will is a document where you indicate your wishes regarding end-of-life care. such as artificial nutrition and hydration, heroic measures, things like that. So basically, your living will is where you document what you want. If you're ever in a situation where you have a complete loss of mental capacity, you're unable to eat or drink without assistance, and you have a condition that's likely to cause death in a short period of time, you can indicate on a living will whether or not you want all artificial measures, heroic measures, machines, breathing machines, feeding tubes, things like that, or you want nothing. You can indicate that in your living will, but in New York State, the living will is evidence of your wishes. It only comes into play, again, if there's a substantial and irreversible loss of mental capacity, you're unable to eat or drink without artificial feeding, and you have an incurable or irreversible condition. Now, it's only instruction to your agent under your healthcare proxy. It supplements your healthcare proxy. It's used as evidence of your wishes and intentions, but in New York State, it is your healthcare agent who is making the final determination. So, although it is not a statutory required form in New York State, we very, very much recommend it because it does remove a lot of the burden from the family members making the decision regarding end of life. Then we have the last will and testament. Now, for the purposes, again, of, working caregivers and setting this up so that it makes life easier for the working elder caregiver who might be caring for mom or dad so that they can get things done that they need to get done quicker. We can't make the things that they need to do go away, but we can make sure that everything is in place so that the things they need to do can be managed, done quickly, and done without stress. The last will and testament is a little bit different. This comes into play after someone passes away, but anything that a person can do to state what their wishes are, who they want things to go to when they pass away, all of that will make life much easier for the child. So a last will and testament is going to set forth how and to whom your estate will be distributed to upon your passing. You appoint an executor to manage your estate and financial affairs, appoint a guardian to care for minor children if there are, and make gifts to whomever you see fit. In New York State, if you do not have a will and you pass away, your assets will be distributed pursuant to the New York State laws of intestacy. That means that the first $50,000 plus 1/2 of the balance of your assets will go to your spouse. The other half will go to your children equally. If your spouse predeceases you, everything will go to the children. If there's no children or spouse, the estate is distributed to parents and then siblings. Most people believe that if you are married and you pass away without a will, everything automatically goes to the spouse. Unless they are joint on all of your accounts, that is not the case. This is how the assets will pass. So what happens if we don't have a power of attorney, a healthcare proxy, a living will? What happens if either your aging loved one didn't know that they could do it, or perhaps the documents were done but they're no good, they were executed incorrectly, or the forms were taken off the internet and they're not specific to New York State? There's a million different reasons why the forms could be not good, for lack of a better term. So what happens when we're in this situation? If the individual no longer has capacity to sign new forms and you need to act, you need to do something with respect to finances or healthcare decisions, you're going to have no choice but to petition the court for legal guardianship. So that means that typically the way it works is a family member will bring a guardianship petition stating all of the reasons why this person needs a guardian, all the things that are wrong with them, all the things they can and cannot do on their own. And the whole point is to get the court to appoint someone to act in their place. So essentially to get the court to appoint someone to act as a power of attorney and someone to act as a healthcare proxy. So when we get into the world of guardianships, we're dealing with first the petition, which your attorney will draft the petition, basically laying everything out, who the person is, who they were married to, who their family members are, what their diagnosis is, what medications they're taking, why they're taking them. And that petition, along with some other court documents, will get filed with the court. And then once that's filed with the court, everybody who's entitled to notice will get served with another document that basically says so-and-so is petitioning for guardianship of Ann Smith, and if you have an issue or you have something to say, you can appear on this day in court. So I'm sure you can imagine in families that there might be a little bit of, of issues between siblings or any sort, or major issues. This is always a tough piece of the puzzle, because now we are putting everybody on notice, and you're going to end up with family members who say, well, this person shouldn't. Why is this person petitioning? They shouldn't be the guardian. This person should be the guardian. And I'm going to get a lawyer and I'm going to petition for guardianship. And now everybody sees the petition. And so now all the dirty laundry is out on the table for everybody to see. The court will appoint somebody called a court evaluator. It's usually an attorney. And the court evaluator's job is to speak to everybody involved. So the court evaluator needs to meet the individual who is, what they say, possibly incapacitated, okay? And that person will meet with the individual to see if they actually do need a guardian. Then the court evaluator will talk to the petitioner, the person who brought the proceeding. They'll talk to all the family members. They'll talk to whomever they need to talk to determine if the person is incapacitated and who the right person is to be the guardian. And we look at the guardian of the person and the guardian of the property. Guardian of the person is going to be the person who makes healthcare decisions, and guardian of the property is going to be the person who handles the finances. So I'm sure you're seeing the pattern here, that if we just had a power of attorney properly executed and a healthcare proxy properly executed, we would not have to go through this guardianship process. And it is a process. Once the papers are filed with the court's supposed to hear the case within 28 days. That does sometimes get adjourned just because of schedules. Once the court hears the case, the court will make a determination. Then we have to file an order with the court, and a lot of paperwork that goes back and forth before the person who is the person who's chosen to act can actually act. One of the biggest concerns I have with guardianships is if there are families who are fighting and really we can't come to any sort of agreement as to who the appropriate guardian would be, the court can actually appoint somebody off a list. Again, it's usually an attorney, somebody who's a third party who has no interest or involvement in the family. Their only job is to make sure that they're taking care of, say, mom or dad in this case. And now you have a complete stranger making financial and healthcare decisions for you or for your parent, and you don't have any say. And that right there is the biggest reason why we push so much for people to have a power of attorney and healthcare proxy, because you're basically choosing the person that you want to make these decisions. You're not being kind of set up with somebody who's off a list, whose turn it is to act in that capacity. So really important to make sure that if you're caring for somebody, that they have these documents in place and that they're the appropriate documents. Have somebody review them, take a second look at them. And I can't stress enough how important this also is for everybody listening, that you have your own power of attorney and your own healthcare proxy, because this has nothing to do with age or health or anything else. Anything can happen to anybody at any time. So having these documents in place is really important for anybody who's 18 or older, because once somebody turns 18, their parents can no longer make decisions for them. So we recommend really that everybody have these, but most importantly for our working caregivers, that the person that they're caring for has these documents in place. Just a reminder, we look at elder care as the new child care. Over 65 million Americans, 29% of all U.S. households are providing care for an adult family member, and these numbers will only grow going forward. So suggesting to your workforce that they make sure their adult family member that they're caring for has these types of documents in place is crucial to making sure that they're able to care for them easily and with less stress. We want you to arm your workforce with the information they need now and avoid a crisis later. Thank you for joining us today, and we will see you next month.